5 minutes past 10. Time to offer you the opportunity to get some free legal advice from our talkback lawyer, David Whiting. 1300 222 774 is the number. 1300 222 774. And somewhat unusually, the phones are usually, well, typically at this time they're pretty much already full. But maybe, I don't know, maybe there's something in the weather. This morning there are vacant lines. 1300 222 774 if you have a need for free legal advice and you want to have a chat to David Whiting. David, good morning to you.
Good morning, John.
Very sad news in the couple of days I was away and over the Easter break. Melbourne lost one of the giants of our local legal community, Brian Burke.
Yeah, extraordinary man. I must confess I never knew him professionally. I never briefed him, but I knew him socially. We for a number of years we were in the same groups that went to the races.
Oh,
and,
okay.
Enjoyed a punt. Fascinating. He never drank, but came from his dad was a publican. Presumably, he learnt while working in the hotels as a young man that sometimes it pays not to.
Yes, more than sometimes.
Yeah.
I'm trying to think of a way of explaining to people who have no knowledge of Brian, although he was a guest on this program recently, and we'll play you some of that in a moment. But trying to explain to people exactly what significance he plays, and the best I've been able to come up with, I guess, what Ron Barassi is to football, Brian Burke was to the Melbourne legal community.
Yes.
Is that a fair description?
Yeah. He wrote a textbook on liquor licensing law. He wrote a textbook on criminal law that ultimately turned into loose leaf services. He was a friend to everybody. There was, as a barrister, as a solicitor, it was an open door policy. You could ask him anything and he'd endeavour to help you. He did, towards the end, as you know, he never applied for silk, even though he was a barrister, never applied to be a QC, even though he was a barrister for 50 years. And he simply just kept rolling on and dealing with lots of people at face value and was really keen on making sure the police paid their part properly.
A mentor to probably thousands, but definitely hundreds of people, generous, and not long ago was a guest in this studio. And now I have to admit to a regret.
And the regret is?
Well, the regret is that Brian came in, he agreed to come in for an interview about a specific topic. I managed to distract him a bit and talk about Ronald Ryan, a case that he was personally involved in. But at the end, he agreed, reluctantly I might say, but under some pressure, he agreed to sit down and do an oral history interview. But I didn't actually do it.
Oh.
Now,
I don't think you would have had enough tape, John. When Brian wanted to talk, the words just kept coming.
He was a gold medalist, but he did agree to come back. He said, all right, well, let's set aside an afternoon. I'll come in, I'll sit down, I'll tell some of my stories. And I said, great, well, let's organise it. And, in the month or so since he promised, I haven't actually done it. And now
And then he got unwell, and then
he got unwell and very quickly, in fact, died after a terrible stroke.
Mm-hmm.
But and great that he didn't suffer. But another time I've had that same regret. A couple of times now I've had that regret with people who have said, yes, all right, I'll sit down and tell some of my stories. And then before you know it, bang, it's gone.
Well, I heard that a couple of years ago he spoke at the Victorian Bar Dinner, where you normally get someone particularly learned. And they got Brian to talk, and everybody had a fantastic time.
Well, he's a raconteur like few others. When he was here to talk about sculpture and the arts. He was also involved heavily in football. But from the public's point of view, mostly, they were interested in the role he played in the last execution of a prisoner in Australia, Ronald Ryan, a man who Brian Burke helped represent. And he was telling us the story, in particular about how the then Premier, Henry Bolte, later Sir Henry Bolte, had determined that for political reasons he wanted to hang someone.
Bolte had determined what was going on, and it was apparent then that Bolte had been prevented from executing Tate, and it was obvious that he wanted to execute somebody, and Ronnie was the boy.
He told us in some detail, and you can go to the website and have a listen to this. It's in our archives. Just look up Brian Burke on the Conversation Hour on ABC Radio Melbourne. He told us about his last conversation with Ronald Ryan.
I can remember going out there to see him, and I spoke to the governor, and he got him brought up, and I was in a room with him in the office, and he was saying to me, I mean, it's pretty hard to talk to a bloke who thinks he's going to die a couple of days later, and this bloke's holding my arm and saying, "You did all you could." Sorry to get upset.
No, you're
myself.
No, that's fine.
You did all you could. I know I will go to the gallows, and I will not be in any way concerned with the fact that those people who represented me didn't do all they possibly could. And anyway, Jack Brosnan confirmed all that in the way they walked up together, and before he went to the gallows. The irony of the thing was they used to invite you to hangings. Fancy being invited to a hanging.
And there were people who were
I was invited.
brought in as witnesses.
I didn't go.
Brian Burke talking about the execution of the last person sent to the gallows in Australia, here in Melbourne, Ronald Ryan. The Jack Brosnan he's referring to was Father Brosnan, the Catholic priest at Pentridge Prison at the time. And the interview concluded with me asking Brian whether or not he formed a view or maintained any secrets from his private conversations with Ronald Ryan, given the passing of the years. Was it time for Brian Burke to give up some of those secrets?
I'm not saying that he told me that he did it. I'm just saying that there were certain conversations with him that I thought were just between the two of us, and I'll keep them.
Even 50 years on, you'll keep that confidence?
However long I live, yes.
However long I live. Well, Berkey, you are much missed, and there are many, many people the sadder for your passing is about all I can say and add to that.
Oh, it's a fantastic tribute.
Yeah, amazing man. Absolutely amazing man. Other things, there's an extraordinary story in the Financial Review today, David. A former construction company supervisor claimed unjust dismissal and bullying and harassment in the workplace because of persistent farting by his boss. The plaintiff represented himself 18 days in the Supreme Court and lost a case for unjust dismissal, for compensation.
For compensation for wrongful dismissal and for the whatever injuries he claimed he suffered.
Claiming
during the course
$1.5
of the
or nearly
employment.
$2 million.
Yes, yeah, and lost.
How can it run for 18 days?
Well, the gentleman concerned was self-represented. All the indications are that self-represented parties add substantially to the length of a hearing, simply because, in a sense, one of the things that you learn as a lawyer is to try and drill things down to their essence.
Yep.
It's a self-represented litigant has a different view of what the essence of the case is,
but
tends to want to add lots of evidence and make lots of arguments.
Doesn't the judge have an obligation to say the court's a precious resource, the community are paying for it? You can't just take 18 days to argue about someone farting at you in the workplace.
Well, I haven't read the transcripts, John. It may well be that there was 18 days of content, but you also, the court needs to recognise that from time to time, self-represented litigants need assistance to make sure that they put their case forward.
All right.
But 3 weeks is a long time. Very quickly, John, a correction from last week. We had a caller last week who wanted to know about the selling of her mother's house, and it was nearly 2 years from Mum's death. And the question was the 2-year period where prices are assumed not to increase starts on the person's death and ceases 2 years after the date of death, not 2 years after the grant of probate.
Right.
And you need to have completed the sale of the property within the 2 years. That is settled. The advice I gave last week was sign the contract of sale. It's settled.
Okay.
Right, that's the first one.
Keep that in mind.
Second one is we had a caller who owned a block of units that he was going to sell, and he never actually had worried about the owners' corporation because he owned everything. Yep. What happened in terms of the rules of the owners' corporation? And because it was a 40-year-old development, the standard rules apply. The standard rules are contained in the schedule in a schedule to the owners' corporation rules. So the fact that it was subdivided under the Subdivision Act didn't help. It's the current rules. And one last one, John. There's a chatbot in the Northern Territory writing wills. The story's on the ABC website. So some years ago, state trustees had a facility where you could give instructions on a website. This is a lawyer in Adelaide or the Northern Territory who has a website that will generate the will for you on the basis of the questions that you ask and the information you provide.
I was sitting in Darwin Magistrates Court last week watching proceedings. Always fascinating. Recommend it to anybody who's up that way. Let's get to today's callers. Charles and Eltham, you're first up with David. Morning, Charles.
Good morning. My call to David and John this morning is about our neighbour who has gone on holidays and his house alarm has been ringing day and night since last Wednesday.
Yes.
And we have contacted the cops, we've contacted the EPA, we've contacted his insurance company, and no one is prepared to do anything about shutting it down. It's driving all the neighbours mad. All the neighbours have made calls to everyone in the area, and nothing has happened, and it's still going on. If I can hold the phone up, you might be able to hear it.
Charles, have you been able to find any relatives or friends?
No one seems to know anything about him except that he's just moved in there fairly recently. He built a property there.
Yes. Have you been able to find the estate agent who acted when the property was purchased?
I haven't been down. No one's been down that track yet.
Well, if you start there, and then maybe you'll then get to the lawyer who acted for the owners, and you might find a connection via that route.
Okay.
And also lateral thinking, the alarm company.
Oh, yes, we've tried them.
Okay.
They're based in Adelaide.
Yes.
They're a well-known company.
And they presumably can't turn it off. They just tell you it's ringing.
Yes, they can't turn it off. There's no access to the property because it's a gated property.
Yes.
And basically it's driving everyone in this area completely mad.
Any suggestions?
It's relentless, day and night.
Other than the one we've given, no. To go off and get a court order requires you to bring it to somebody's attention.
Yes.
So the only one I can give you is the way I suggested. Sorry.
All sorts of ideas come to mind, but let's just follow through.
An unlawful one would be to look to see if the return addresses on letters in their letterbox. But that's, you're not allowed to go through someone else's letterbox. That's an offence.
Charles, I'll pop you back to my producers. We'll see if we can do some work on this as well. Elizabeth in Brunswick, good morning to you.
Oh, good morning. Look, I'm ringing up on behalf of my son. He moved into a townhouse in January. And he knew at the time that the owner wanted to sell, and he agreed to one inspection. But over the last 3 months, he wasn't expecting 8 or more inspections. He's notified the agent he doesn't want inspections because the agent wasn't even giving the 24 hours notice in writing. But even worse than that, another agent, not his landlord's agent, contacted him, having got his phone number and email somehow.
Yes.
And what can he do about this situation?
Well, I don't have a problem with the phone number and the email in the sense that the second agent, is now representing the owner. Right?
Okay.
Now, right, so, since it's like I've appointed another agent to see if I can sell the property, I want that person to liaise with the tenant. Is there anything in his lease about open for inspections?
No.
Okay, so your starting proposition, Elizabeth, is that the open for inspections arise under the landlord's right to inspect.
Right.
Okay. So so I'd come along and say, sure, open for inspection, but there needs to be an agreed frequency.
Yes.
And I need to know who's coming.
Yes.
So by default, it can't be an open for inspection.
So
in the sense that, well, look, we're open for an hour, anybody can walk in. I'd come along and say, look, I'm the tenant. If you want to continue on that basis, you've got to give me some compensation. Otherwise, I think that you've now done 8 of them. You found nothing untoward about the property in that period of time. I'm happy to agree to inspections that are perhaps...
the inspections are of people wanting to buy the property.
No, but that's exactly my point. The purpose of the inspection is for the landlord to assess the premises, to make sure that the tenant's not in default under the lease. So,
no, but these are people who want to buy the property.
I understand that. I understand, but they have no right of entry.
Who don't have the right of entry? Sorry,
but those people don't have the right of entry unless they come with the landlord or the landlord's agent.
Is that right? So if you're a tenant living in a property that's for sale, you don't have to agree to potential buyers coming through to have a look.
Well, I've always said if I'm acting for a vendor in that situation is do a deal with the tenant. Reduce the rent, do something.
Offer them some compensation. Has your son been offered any compensation, Elizabeth?
No, he's thinking about moving altogether and wondering if he has to go to VCAT or something.
Okay.
Well, why would he not ask the landlord? Well, look, you've got to work out what your ultimate objective is. If he wants to remain and have quiet possession, then he just closes down the open for inspections. So, yes, you can inspect the property tomorrow afternoon at 3, but give me the list of the people who are coming.
Okay.
And that won't work on the open for inspection model. And then I think unless you find something untoward, unless the agent finds a problem with the premises, there's no logical reason why they should come back for another 6 or 8 weeks or more.
All righty.
Okay.
Okay, Elizabeth,
all right.
Hope that helps you. The consensus by text message, David, for our first caller about the alarm that doesn't stop ringing,
yes,
seems to be to act illegally in a number of different ways, including break into the house, find the alarm box and pull it out of the wall. I think that's probably going a bit far.
Yes.
Cut off the power to the property.
Yes.
And then the battery backup will eventually die.
Yeah.
Which is also illegal, and you don't know what other things...
You don't know whether there's a freezer full of something.
Exactly.
You just don't know what the
You just can't do that to your neighbour's house because you're annoyed by not just a freezer full of something, but you don't know what other systems are operating within the house. So that's not particularly right either. So people seem to think that you can just pretty much just go and take the law into your own hands in that situation, which doesn't to me seem right at all.
But if you can find out who sold the person the property, you might go pick up an email address or a phone number.
Something like that. Trevor in Frankston thinks he's got an answer. Trevor, morning.
Good morning, John. It's possible that it could be a fire alarm. I'm actually a firefighter.
Okay.
It could be a fire alarm, not a burglary alarm. If it's a fire alarm, ring the fire brigade. They will go, and if it's a fire alarm, they'll get into the place and disable it.
Okay, so in fact, even if you're not sure what it is, if you tell the fire brigade...
We get calls like that all the time for alarm operating, and 90% of the time they turn out to be faulty fire alarms.
And the fire brigade are authorised to enter, aren't you?
Got rights of entry under the Act.
Yeah, so fire brigade can enter the property, sort out whatever the alarm issue is, and then seal it up again.
Yep.
Trevor, thank you.
Thank you for that, Trevor. Yeah, I'm glad I don't live in Eltham for that reason.
Lateral thinking, absolutely. Lynette Lynette's gone. I was coming to you next, Lynette. Sorry about that. Leslie in Kew. Morning to you, Leslie.
G'day, John. I just wanted to ask David about the rights between de facto couples and married couples. I seem to remember David made some comment that there was more rights if you're married than if you're in a de facto relationship. Is that right?
Yep.
Can you tell me them?
Your rights as a married couple arise the day after you get married.
Yep.
The presumption in a de facto,
the day,
in fact, after you both. So I now pronounce you
man and
partners.
Wife.
I wasn't going to go man and wife.
Okay.
Right?
Yeah.
I'm trying to be very inclusive, John.
Sorry, I should too.
So the moment you're married, you have rights under the Family Law Act. All right. De factos don't acquire those rights for a period of up to 2 years.
Okay, and what about 20 years?
Well, then they're the same. At that point, they're the same.
Oh, great. So it's just you have to wait 2 years before you have the same rights. Is that what you mean?
Yeah, I'd hate to think you were waiting to get the same rights.
No.
Leslie, I mean, it just so happens that 2 years on you have the same rights, but it seems to me the relationship is flawed if you're waiting for them.
No. It was just I remember hearing you making that comment, and I wasn't sure. I mean, I'm happily in a
long-term stable relationship. No, the answer is your rights are the same. All right.
Beautiful. Thank you so much, David.
Thank you, Leslie.
All right. Good on you, Lee in Melbourne. Morning to you, Lee.
Morning, John and David. How are you today?
Good. Welcome.
Just my question is, I've been trying to get some legal advice about stopping a builder from opening every 6 months to a year. He opens new building companies. He's not paying his bills, and he causes so much heartache. And
now, is he a registered business person, a registered builder?
He's not. What he does...
So he's got a handyman type business, has he?
Yes.
And are they companies that he opens each time?
They're companies, PTY Ltd companies. But what he does is he went into liquidation about 2-3 times under his own name. Then he changed his name to a couple of times, and then he started putting friends and relatives and started paying people to become the directors of his company.
Now, this is called phoenixing, Lee. It's been a feature of Australian corporate skullduggery for as long as anyone can remember, where you shut down on Friday and open the same business under a new name, but effectively keeping the old business going without picking up its debts on the following Monday. It is illegal, but very hard to police, David, isn't it?
Well, particularly, I mean, Lee, there's the phoenixing where it's the same person each time. That one you can report to ASIC. But where it's different people each time, it gets hard for you to prove, but ASIC are the people who police the phoenixing. So you just come along and say, I think that Builder X is the person behind this company. And that's what, so you give ASIC the list of all of the ones that you found and the fact that they've failed and that they appear to be running substantially the same business with the same phone numbers from the same address. And that, there are now other companies doing exactly the same thing, but the person who answers the phone, who turns up to do the quotes, is the same person.
All right.
That's the process.
I did that. ASIC told me that they cannot do anything about it. I should take it legally. But he's been doing this for about 15 years.
Yep.
I personally know him for 12 years.
Yep.
He's been on TV on
the problem
on the
problem,
news.
Lee, is that you want someone else to run the case. Now, what you could do if you were really game is that you could run ads that said exactly what you're talking about, and then have him sue you and the newspapers or the billboard companies if you turned out to be wrong. But the issue is really one of resources from the policing authorities.
All right, I've got any number of people joining in still on the burglar alarm that doesn't get turned off story, from people saying all sorts of things to do with the creative use of a golf club.
Yes.
Through to...
That assumes that it's on the outside of the house, John.
Through to... Yeah, look, I like this one, though, from... Where is it? Someone in Ray and Corio. You can go to the hardware shop and buy expanding foam.
Yes. And
spray it into the alarm box.
Yes.
Apparently it crushes the noise, stops the noise and suppresses any sound.
Oh.
So, yeah, Ray from Corio passing on a trick.
So you learn a lot here, don't you?
He may well have learned that when he was doing his time in youth detention. I don't know. We had an old car with the alarm going on all night. Someone broke in under the bonnet, smashed the windows. No one got any sleep, says John in St Kilda. I feel sympathy for these people. If you turn off the power to turn off the alarm, and then you turn it on again to save the neighbour's freezer, does that solve the problem? No. Someone else saying, call the police and tell them you think there might be someone in trouble inside, and they'll go in and do a welfare check. Oh. Which is it's a variation on the fire brigade thing that was suggested before. But let's keep moving through. And Annie in St Kilda. Morning to you, Annie.
Good morning, David and John. I bought a house last year, and about 6 weeks after moving in, I noticed that the water was damp outside the bathroom, the ensuite bathroom. And
sorry, the water was damp. You mean the wall was damp?
No, the carpet was wet.
Ah, the carpet, yes, okay.
Yeah. Well, the inside of the house. Outside the bathroom, but inside the house, yes?
Yes,
yep.
Sorry. And anyway, long and short, it's taken sort of like 4 or 5 months, but I've had builders, plumbers and architect have a look at it, and it turns out that it's been leaking. The shower or the membrane of that bathroom has been leaking for, they would say, about 5 years.
Yes. Was it not apparent on inspection before purchase?
Not apparent on inspection, except that there was some faded carpet near the bathroom where it meets the tiles.
Yep.
And I said to the real estate agent, what's that? And he said, oh, I'll check on it for you. And he came back to me and he said, the owners say that they had a leak in the shower, but it's been fixed.
Okay.
And I took them at their word.
How old was the bathroom, Annie?
It was done in 2010, so not very old.
There might be a builder's guarantee. There probably
no, I
won't
understand
be.
that's 7 years.
Yeah,
I think.
6 years and 6 months.
Something like that. Yeah.
So no.
I've checked that. Yeah.
So
but what a friend of mine said to me is that because it's misleading and deceptive conduct, the plumber, the builder, everyone says they couldn't possibly have been using that bathroom while it was for sale. They must have been using the downstairs bathroom.
So as not to make it obvious there was a problem.
Yes, because I only found out
Annie,
6 weeks because it was quite a slow leak.
Is that in order to catch the deceptive and misleading, it needs to be in trade or commerce. So if I was a professional builder and I did up houses and sold them and you bought one from me, in those circumstances you would have a claim against me.
So the vendor is not engaged in trade and commerce with Annie. Hang on, Annie, but the estate agent is?
Well, it depends. You're going to have to prove that the estate agent was told something different to what he passed on to Annie.
Yeah, and look, he's not going to do that. I've already asked him to make a statement and he won't even do that.
Yeah. Any cost of rectification? Have you had a quote?
Yeah, no, I've had it done because I couldn't live with it. It came to about $27,000 all up because they had to pull out the whole bathroom.
Okay, can Annie go to VCAT? Has she got the...
the problem is she's got no claim against the vendor unless she can prove it was in trade or commerce.
What about for breach of the contract of employment, where the contract of sale in the Section 32 where you're supposed to disclose these sorts of things?
No, you're not supposed to. Sorry, it's not. I have these problems from time to time. There is a list of things you are required to disclose. Mm-hmm. There's a whole list of other things you might disclose, but you're not required to.
But you send all those what are they called, requisitions on title? You send all these questions.
No more requisitions on title.
Don't you have questions that you send saying, is there anything you should tell me?
There are a series of well, no, that's not a question as to title. The nature of requisitions, which were a series of questions that a purchaser was entitled to ask a vendor, went to title. It's to what you own, not the quality of what you own.
Right.
Yes, sorry, Annie?
So there's no I was told that a building inspection wouldn't have uncovered it. It was a very slow leak, and that's why it took 6 weeks or something of me using the shower every day for the carpet to become wet. And when you lifted the carpet, you could see running water, actually. But it took 6 weeks of daily use of the shower. So there's nothing that says that they deliberately hid something.
No.
That's extraordinary, don't you think? A building inspection wouldn't have revealed it.
No, you often get to the situation, Annie, where it's a question of not knowing. I mean, I don't. If you were to buy from me, I don't know what it is you want to know. If you're going to pull the house down and build something else, there's a whole lot of things I wouldn't tell you because you didn't need to.
Is there anything Annie can do for a $27,000 worth of loss?
Not unless she can prove an obligation of the vendor that was breached, and the deceptive and misleading conduct provision only applies in a trade or commerce.
One more idea, Annie. Did you have a pre-purchase inspection by a builder or an architect?
No, but the architect later told me that it wouldn't have been revealed because you couldn't see anything, nothing was damp.
Yep.
He put stuff on the wall. They
managed to disguise it. All right, well there you go.
They just hadn't used it.
So then my final answer is this: if the problem's been fixed, then why don't you ask the vendor for copies of the invoices that were provided by the people who did the fixing, so that you can have a talk to them.
All right. Good luck there. Final word on burglar alarms?
Yes.
Has anyone thought there might be a burglar in there who might be getting very hungry by now if they run out of food? Anyway.
Thank you, John.
That's just the last text message on the topic. David, look forward to seeing you again. In fact, I won't be here next Tuesday just for the day, but I'll see you the week after.
Look forward to it. Thanks, John.
Look forward to it then. David Whiting, our talkback lawyer, helping you with free legal advice.